Hello, everyone. The Supreme Court Collegium made a lot of headlines this week. The week started with the reports regarding the Law Minister writing to the Chief Justice of India, requesting that a search cum evaluation committee be constituted for the appointment of judges by including some representatives of the central government. While a lot of debates were going on regarding this proposal made by the Law Ministry, the Supreme Court Collegium made a very unprecedented move. On last Thursday, the Supreme Court Collegium published a statement by detailing the objections raised by the central government and detailing the reasons cited by the Supreme Court Collegium for rejecting those objections. And some of those objections are quite frivolous and quite arbitrary. For example, the sexual orientation of a candidate was cited as an objection. In another case, some social media comments expressed by a candidate was raised as another objection. And with respect to another candidate, the fact that he shared an article which was criticizing the Prime Minister, that was cited as an objection. So the Supreme Court Collegium came out with a detailed statement rejecting all these objections and recommending these names, reiterating these names with a direction that they should be processed very expeditiously. So in this backdrop, when there is a lot of discussion going on about the Supreme Court Collegium, we are having a discussion with former Supreme Court Judge, Justice Madan B Lokur. Welcome, sir. Thank you for joining us.
Thank you. Thank you.
Justice Lokur retired as a very senior judge of the Supreme Court, and he was a member of the Supreme Court Collegium as well. And more significantly, he was one of the members of the Constitution bench, which delivered the NJAC judgment. And he had also written a separate judgment detailing the reasons for striking down the Constitution amendment. So before diving into the main issues, I would like to have a brief discussion about the MOP, the Memorandum of Procedure for Judges Appointment, because there is a lot of confusion even amongst lawyers regarding the status of MOP. So the Supreme Court, in the recent case filed by the Advocates Association of Bengaluru, the Supreme Court stated that the MOP, which was finalized by the CJI in 2016, that is the final MOP, and the central government cannot act as if there is no MOP existing. But if you go to the website of the Department of Justice, we see this old MOP of 1999. The old MOP is still uploaded. So there is a lot of confusion regarding the status of MOP. So in this backdrop, could you elaborate a bit regarding the status and the situation regarding the MOP?
Yes. First of all, let me thank you for inviting me for this discussion. You see, it's like this. Before the before the NJAC judgment, there was an MOP in existence of 1999. Now, whether the MOP that is on the website of the Department of Justice is the 1999 MOP or the 2016 MOP, I'm not 100% sure, because I don't remember what were the significant differences. But anyway, after the NJAC judgment was delivered, the court felt that some changes are required in the functioning of the Collegium and in the Memorandum of Procedure. So the court said, the Constitution bench said that suggestions may be given by the public, which can be discussed and probably incorporated in the new MOP. So if I remember correctly, something like 11,500 pages or 11,500 suggestions were received. And it was obviously a Herculean task to try and sort it out and, come out with a new MOP. But two learned senior advocates, Mr. Arvind Datar and Ms. Pinky Anand, took up the task on the request of the Supreme Court to sift the suggestions, and they gave a report. The Attorney General for India at that time said that, listen, the drafting of the MOP is the job of the executive. It is not the job of the judiciary, which was accepted. And a draft was given by the government. I don't know to what extent the suggestions were incorporated, those 11,500 suggestions or 11,500 pages. But the Supreme Court, the Collegium of 5 judges, did go through the draft gave its suggestions and sent it to the government in 2016, right? After that, I believe sometime in 2017 July, I'm not 100% sure again. I think sometime in July 2017, the government sent a letter saying, three things, which letter was addressed to the Chief Justice of India. And in the winter session of Parliament that year, on the basis of a question that was asked by some honorable member of Parliament, it was revealed that the government of India had sent three suggestions or three objections, or three issues for consideration. It was not known until then. And the reply that was given by the minister, the honorable minister to the honorable member of Parliament was that we have sent a letter in July and there has been no response from the Supreme Court. This was actually discussed, if I remember correctly, in 2018, because the existence of the letter came to be known only in December 2017. And they were told, the government was told that, listen, whatever has been said is final. Okay. And that is the memorandum of procedure, or at least what had been conveyed by the Supreme Court. There was no further response from the government, as far as I'm aware. And, that's been operational since then. So really, but I don't think there's too much of a difference between the MOP that is on the website of the Department of Justice and the MOP that was sent by the Supreme Court. First of all, I'm not even 100% sure whether it's the same document or a different document, but even if it's these are different documents.
In the order passed in the Advocates Association case also, the Supreme Court stated that the 2016 MOP is more or less similar to the 99 MOP.
Yeah, you're right. You're right on that. It's more or less similar. There's no substantial change, Yes. So that is one that is, being operated upon by everybody.
So right now, when the reports regarding the law minister's letter came in media, the law minister responded in a tweet stating that the letter has been sent in furtherance of the Supreme Court's directions in the NJC judgment, and there was a need to restructure the MOP. So did the Supreme Court judgment in the NJC case, did it contemplate the constitution of something like a search cum evaluation committee with government knowledge?
No. You see, like I said, the draft was sent by the government, and I don't remember, any search and evaluation committee or any such thing being mentioned in that draft which was sent by the government. So, the fact that some changes were required was mentioned, in the subsequent to the judgment. That's when those 11,500 pages of suggestions were received. But something like a search and evaluation committee or representative of the government and the Collegium, that was never the subject matter of discussion.
So, sir, just to clarify, so the MOP is essentially detailing a broad timeline and what should be the response of the governments at each level. Proposals, and it's not something related to the composition of the selection body. For example, that is something judicially declared.
Yeah, you see, it's only the procedure that is to be followed, right? That's why it's a memorandum of procedure. But the constitution of the Collegium is there. It's a judgment of the Supreme Court. So, nobody can change it except the Supreme Court or a larger bench of the Supreme Court.
So how do you see this proposal of trying to include government representatives in this process through the search cum evaluation committee or any other body? How do you see, won't it be then in effect changing the composition of the selection body?
Yes. If there is, you see, it's like this, one is the principle, okay? The principle being that the government wants a representative in the collegium. Okay. What are the details? We don't know, because that's not been disclosed. For example, what is the role of that representative? Okay. What is the level of that representative? Is it going to be the minister? Is it going to be the secretary? Is it going to be some other official? So that's a part. That's on the presence of the representative. The principle is that should a person who is representing the government, should that person be a member of the collegium, right? That principle is wrong, because the Supreme Court judgment does not postulate an outsider being a member of the collegium. So you can't have a person, whether he's or she is a representative of the government or whether it's an outsider. So that is something which in principle is wrong. You see, now assuming it is correct, then further questions will arise. Who is it going to be? What is the role of that person? Does that person have a veto power? So on and so forth. But in principle, getting an outsider in the collegium is contrary to the judgment of the Supreme Court.
So, but the government's position is that the executive also should be having a role in the process of appointment of judges, and leaving it completely to the collegium. That is not something which is contemplated under the Constitution. That is that is a counter argument.
Yeah, you see, now the government does have a very major role in the appointment of judges. I don't know why that is being said by the Honorable Minister. Under the MOP, right? Let's take the appointment first of judges of the High Court. Okay. Now, the Collegium of the High Court, consisting of the Chief Justice and 2 senior judges, make a recommendation. They can make that recommendation, after consulting other judges, after consulting lawyers, whomever they want to consult. I remember as Chief Justice of Guwahati High Court and Chief Justice of Andhra Pradesh High Court, I consulted judges outside the collegium also, okay, because I was new to the place. I consulted senior lawyers. I know that Chief Justices in Delhi also consulted lawyers and judges outside the collegium. So there's nothing wrong, okay? So the High Court Collegium then decides on some names, 1, 2, 3, whatever. They send it to the Chief Minister of the state, okay? As a matter of courtesy, I don't think it's there in the memorandum of procedure, but as a matter of courtesy, that list is also sent to the governor of the state. But in any case, it is sent to the Chief Minister of the state. The Chief Minister of the state can raise objections or can make his comments or, say something or the other, whatever. So can the governor, for that matter, because the list is sent to the governor. Then it is sent to those comments, or that list is then forwarded by the Chief Minister to the Law Minister in the Government of India, to the Department of Justice. They can also process the case, which they do. All right. If they want to say something, they're free to say, that this person is not suitable, or this person is suitable for this reason, or not suitable for this reason. It's entirely up to the central government, like it is entirely up to the Chief Minister of the state. Then that entire material is sent to the Supreme Court Collegium. So the Supreme Court Collegium has before it the views of the Collegium of the High Court. It has the views of the Chief Minister of the state. It has the views of the Governor of the state. It has the views of the Government of India. And then the Supreme Court, it's not that the Collegium, the Chief Justice and 2 senior most judges sit down and say, oh yeah, we've got the file and let's take a decision. They make independent inquiries, in the sense that the Chief Justice of India will write to judges of the Supreme Court, sitting judges of the Supreme Court, who have been associated with that particular High Court. They may have been associated with that particular High Court either as a judge of that High Court at some point of time, or as the Chief Justice of that High Court. Now, there are instances where there are 4 or 5 judges of the Supreme Court who have had an association with a particular High Court in some capacity or the other, either as a judge or as the Chief Justice. Their views are taken. And once all that material is there, High Court, Chief Minister, Government of India, and sitting Supreme Court judges, then the Collegium takes a decision. And they say, yes, we think this person is right. Or depending upon, what is mentioned in the material that is forwarded, we don't approve of the name, or we send it back for reconsideration, whatever. So with this elaborate process, I don't see how, the Government of India can say that it has no role to play. It does have a role to play. The State Chief Minister has a role to play. So it's not that the, judges appointing judges kind of thing, because all the material is there. All right, then it is sent to the Government of India with the recommendation. All right. Now, what the Government of India does is, and they've done it in several cases, they look at the views of the Supreme Court and, send the file back to the Supreme Court for reconsideration. Now, the thing is that whatever the Government of India had to say, it has already said. And the Supreme Court Collegium has taken a decision on that. All right. There may be a case where there might be some additional information that has come in between. From the day when the file was sent to the Supreme Court Collegium and the decision conveyed by the Supreme Court Collegium, there might be some new material. With that new material, the file is sent to the Collegium. And then the Collegium looks at that new material and then takes a call. They say, yeah, maybe this new material is important and we should not have made that recommendation. Or it says that, no, we don't think this new material is relevant. And we reiterate the recommendation that has been made. Then the government must accept that. It can't say, okay, now, we've got some more new material. I mean, that'll never end. Then it'll just go on and on and on forever. So that is how the system works. Okay. So I really don't see, what the complaint is, so to speak.
So now the latest reaction by the Supreme Court Collegium. How do you see that latest reaction? So in an earlier interview also, you have said that the Supreme Court Collegium should assert itself when the government is repeatedly ignoring even reiterated names.
Yes.
How do you see this instance of the Supreme Court Collegium putting it on record, the center's objection, and also its detailed reasons for discarding those objections? And this is an unprecedented action also. So
yes.
Do you see it as an action of the Supreme Court Collegium asserting itself?
Yes. You see now what would have happened in all these cases. Okay. We don't have access to the records, but what would have happened if this procedure had been followed? The Supreme Court would have made a recommendation to the central government saying that, yes, these 5 persons should be appointed. All right. Which means that the objections that were raised earlier were on record. There may have been some new material, I don't know. And on the basis of that new material, the central government has sent the file back to the Supreme Court for reconsideration. Fair enough. One of them, as you said, pertained to sexual orientation, which was a fact that was known a long time back. Okay, it's not that the sexual orientation suddenly came up, it was a new material. So really it was saying that, we've brought this to your notice and we are again bringing it to your notice. Supreme Court says, well, we knew it, and we are reiterating the name. That's it. In one of the cases, there was no material at all. Absolutely zero material. And the Supreme Court has mentioned it in its statement that there's no new material. I think it was one of the judges of Calcutta High Court. They said there's no new material. So why did the government send it back without any material? Which is to say that, listen, Supreme Court may have a view, but we have a different view, so we are sending it back. But why? I mean, you just can't say, I want to send it back, so therefore I'm sending it back. It can't be like that. Social media posts. The social media posts were of 2017. The government didn't know about it. What were they doing? And is that an objection, that just because you made some social media post or you discussed something about some cases? Everybody discusses about cases. What's wrong with it? So the government said that these are the objections, and the Supreme Court did well to record what those objections are. And in one case, there was no objection at all. And no material at all. And say that, well, we've considered whatever you have to say. And these are our reasons for not accepting what you have to say. And therefore, we are reiterating those recommendations. Now, I don't know what the government will do. The government may again send it back, without any material, or they may act upon it. They should act upon it. That's the law. They have to act upon it. And let's see how much time they take to act upon it, or what they plan to do. I have no idea. Anybody's guess.
So now another interesting aspect of the Supreme Court Collegium's latest statements is that so it has kind of exposed the priorities of the central government, or the kind of objections which the center is making. For example, in the case of sexual orientation, they said that the candidate's passionate support for LGBT rights, that may give rise to an apprehension of bias and prejudice. That's one reason stated. And also in the case of another candidate, the center said that he has shared an article which was critical of the Prime Minister. So do you think that the kind of objections raised by the central government, do you think that they point out to the fact that, or indicate that the center wants judges who are aligned with its ideologies and principles, and who may not criticize the executive?
Yeah, it's quite clear. It's quite clear they want persons who are aligned with their kind of views. Now, the sexual orientation case, all right, does it mean that this particular judge, during his entire judicial career, will only hear cases of sexual orientation or LGBT rights? He will not hear any other case, and therefore he's biased? I mean, isn't that ridiculous? I mean, there's so many other kinds of cases. And it's not that he's going to hear only one case or the same type of case throughout his judicial career. And somebody has criticized the Prime Minister, all right, that's an expression of a view. But what has he done? If I remember correctly, he has forwarded an article.
Shared an article.
Shared an article. Right. But then what about the person who has written the article? What has happened about him or her? Has the government taken any action against that person? So you share an article which says something good, or you share an article which says something not so good. Is that a crime? Are you supposed to only share articles which are good, which say something very good about the government? In other words, you can't share articles which are critical. What is that? What is the message being sent?
And we also see people who are openly praising the Prime Minister also getting elevated and or recommended soon. So that is also other side of the picture.
Yeah. There, of course, the question of bias, does that come in or does it not come in? So it can't be both ways, it should not be. And in any case, I think freedom of expression is important. Freedom of speech is important. And today, somebody may be critical about the Prime Minister. Tomorrow, that same person may not be critical about the Prime Minister. That's also possible. Today, somebody may be critical, may not be critical, or will praise the Prime Minister. Tomorrow may be critical. That's also possible. So, why can't people express their views?
So, so do you think that the government's inquiry in the entire process is only limited to whether limited to ascertaining whether the person is aligned with the government's views and policies, and not whether the person is suitable for judgeship? That is because such a ground is not taken anywhere.
Yeah. You see, from whatever has been disclosed in the recent past, the government does not know or does not appear to know why it is objecting to a particular person. It could be on grounds of ideology. It could be on, just because I have the power to oppose, therefore I will oppose, like in the case of the Calcutta recommendation. There's no ideology because there's no reason given. There's nothing given, so why was it sent back? So we really don't know, what is going on in the mind of the government, except perhaps that they want, people of their own choice, a committed judiciary.
So in this backdrop, when we see the proposal of the law minister to have a search cum evaluation committee, so how do you think that will affect the entire process? And
yeah, what is the role of the search and evaluation committee? Is it being suggested that the Chief Justice and the judges of the High Court do not carry out a proper search? Is that what is being suggested? Is it being suggested that the Chief Minister of the state does not do his duty? Incidentally, the MOP mentions that the Chief Justice, that the Chief Minister of the state can make a suggestion to the Chief Justice of the High Court. So what is the search and evaluation committee going to do? And how are they going to search? The judges of the High Court have been there for perhaps about 10 years, right? As judges. They've been lawyers over there for about 20 years. So they've had 30 years of experience in that particular High Court. The Chief Justice may be a new person, maybe somebody with a couple of months experience or maybe a couple of years experience. But the other two judges have got at least 30 years association, or about 30 years association with the High Court. Now you get some outsider to come and do some search. How improved or how better is the search of that other person going to be, of the outsider? If it is an insider, somebody who is associated with the High Court, well, the judges of the High Court are ideal for this purpose. Why do you need somebody else? Are you doubting the integrity of the judges? What is it? So it's not very clear. What is the role of this search and evaluation committee? Is the search committee going to say that, listen, we think this person should be appointed? The Chief Minister can do that. Okay. Now, the judges can ask other judges. They can ask lawyers. Do you have anybody in mind? Maybe we overlooked somebody for some reason. Suggestions are given. So, again, one doesn't know what is the search and evaluation committee going to do? What is its role? Is it going to say that, the search that you have conducted is not correct and you should not recommend a particular person? Is that the role of the search and evaluation committee? I don't know. Nobody knows. So let's have the details. I mean, unless it's some kind of a top secret or something, let's have the details.
Now, these days there is a lot of debate regarding the NJC judgment also, and so there's one strong ground of objection which has been repeatedly taken is that the NJC amendment was passed by the Parliament unanimously and also with the support of the majority of the state legislatures. So the Supreme Court striking it down, that is something which is going against the will of the people. So this is one view which has been expressed. So recently the Vice President also repeated the same argument by saying that the Supreme Court judgment has kind of diluted the supremacy of Parliament. And he has also questioned the basic structure doctrine also, and has said that the Kesavananda Bharati decision has set a very bad precedent. So how do you see the criticism to NJC judgment on this ground, that the parliamentary supremacy and the will of the people has been impacted?
Yeah. You see, I don't want to speak too much about the NJC judgment because I was one of the authors of the judgment. But you see, the thing is, it's the Constitution of India that is supreme. All right. The judiciary is not supreme. The executive is not supreme. Parliament is not supreme. It's the Constitution of India that is supreme. And if something is done contrary to the Constitution of India, the courts can say, and that is their job, the courts can say that this is contrary to the Constitution, and therefore it is unconstitutional, and therefore strike it down. Now, in the NJC judgment, the Supreme Court felt, and they've given reasons, that the amendment to the Constitution violated the basic structure of the Constitution in the sense that the independence of the judiciary was being taken away or was being compromised. And therefore, since it violated the basic structure of the Constitution, therefore, it was declared unconstitutional. Like I said, the Constitution is supreme. And whether the legislature passed it with an overwhelming majority or unanimously or with a thin majority is irrelevant. If it is unconstitutional, it is unconstitutional. That's it. Who decides whether it is unconstitutional or not? That has to be decided by the judiciary. And the judiciary did that. One may say that the judgment is wrong. Okay, fine. You can have your own views. Some may say judgment is wrong. Some may say judgment is right. Fine. That's perfectly okay. But it's the judiciary that has to decide whether a particular law or an amendment to the Constitution is violating the basic structure. Yes, if it is, it's unconstitutional. If it is not, fine, no problem.
Right, sir. So, sir, thank you so much for sharing your views on this topic. Thank you.
Thank you. Thank you.